You better die or I'm gonna stab you. Stab, stab, stab. Wow, shook. Hi everyone, my name is Josephus Tan. I'm a criminal defense lawyer. Of course, I know I look more like a criminal. It's fine, I get that a lot. Oh yeah, in case I forgot, this is my partner in crime, Ba Zhang. Look at the camera.
How to get away with murder.
The main difference between a murder trial and a non-capital criminal case is really in terms of the length of time involved. It's because of the sheer volume of documentations and the witnesses involved. When we talk about documentation, we are talking about scientific or medical reports like psychiatric report, toxicology report, autopsy report, lab testing report. We even have like reenactment report or even actual reenactment itself in a courtroom. So this is very unusual, something that you won't ordinarily see in a non-murder or non-capital case. That explains why a typical murder case will take anywhere from 1.5 to 3 years to complete. We are really talking about from the first day of arrest of the accused and all the way until the completion of trial, whether is it ending in an acquittal or a conviction. And thereafter, if upon conviction, there might also be another stage you might want to appeal to the Court of Appeal. And assuming that if that fails, the conviction is secured at the Court of Appeal, and if the death penalty is maintained, and the ultimate last stage will be that of precedence clemency, that might potentially be another 1 or 2 more years. So there are 4 different types of murder in Singapore. So pretty much like what you see in Hollywood movies where they talk about first-degree murder, second-degree murder. There is something equivalent like that. But in Singapore, we call it Section 300A, B, C, and D of the Penal Code. So first thing first, we talk about Section 300A. Everyone out there will probably have this stereotypical understanding of what a murder is. Nothing does it better than a demonstration. One is Section 300A. So imagine this cute little face, okay? And this is what I'm gonna do to it. You better die! Okay, I want you to die. I've been planning this for a long time. Okay, I'm gonna pull out your head or I'm gonna stab you. Stab, stab, stab. Wow, shook. 很爽. Dead. Done and dusted. So really the intention is to cause the death of that person. This is really murder at the highest level. So now we come down to Section 300B. Nothing explains it better than really giving a chocolate to Ba Zhang. Cannot, you eat already, you'll die, you know. You got allergy, huh? Right, the person got allergy. Same thing, I think the audience out there will know that, I think by way of analogy, if you give chocolate to a dog will die. Hey, don't stone me. This is 300B of the Penal Code. Section 300C of the Penal Code. Again, to give everyone an analogy, is simply this. I decided to use a baseball bat to hit somebody on the head or to use a knife to stab somebody in the chest, and the person died as a result. That action of assault in the ordinary course will cause death to anyone because these are at the vulnerable spots of the human body. But what if, let's say, I turn the factual matrix around? I repeatedly punch the person in the head. If you want to add more flavor to this, right? What if, let's say, I'm a trained MMA fighter? Eventually, my punches cause the head to fracture. As compared to, for example, maybe I just punch you on the shoulder, whereby in the ordinary course, it wouldn't cause death. It will cause blue black or chi, you know, as compared to hitting the head multiple times, you know, creating a fracture. Coming down to the last one, Section 300D of the Penal Code. This is by far quite rare in Singapore, but to give again an analogy, when I throw a hand grenade into a crowded shopping mall, it is not targeted at anyone specifically, but by that very dangerous act of throwing that hand grenade and knowing that upon explosion, it will severely injure or cause death to the people inside the mall. This is Section 300D of the Penal Code. Well, the answer is yes. Probably a lot of question marks, right? I can see the top bubble, you know. But the answer is yes because of this thing called the circumstantial evidence. And it has happened before in the past. So whereby the so-called victim or the deceased body wasn't found. But yet, the accused was properly convicted on account of murder and subsequently sentenced to death. Imagine this to be a jigsaw puzzle. You might not have really all the pieces, but perhaps a lot of the pieces start to fall in place to form quite a sensible interpretation of the image to point in a certain direction of the accused guilt. So that is what you need to know about circumstantial evidence. There are a few exceptions to a charge of murder. Of course, if you succeed in one or more of these exceptions, or what we call defenses, then you can potentially escape a murder conviction. So first things first, we have this defense by the name of grave and sudden provocation. So as the name goes, basically you have been provoked into the killing. But of course, ultimately, in terms of the nature and the severity of the provocation, that one is a matter of facts. It's really on a case-to-case basis, really up to the court to decide. Going on to the second defense, okay, this is the defense of diminished responsibility. I know it sounds like a mouthful, but long and short of it, it means the accused person has mental illness. And at the time of the killing, this impairment of the mind resulted in the person committing the killing itself. Really, the analogy is this: the human brain is like a car. The driver is inside the car, but maybe the driver fell asleep. Let's say, for example, the car got no driver. That means this person is clinically insane. Two different types. So for diminished responsibility or an impairment of the mind, okay, which is backed up by medical evidence, is different from clinical insanity. So going on to the third type of murder defense would be the defense of sudden fight. Some of you must be thinking that, it's a bit strange, right? The name sudden fight. But as the name goes, it is sporadic, it is spontaneous. There was no premeditation whatsoever. There was no intention of killing anybody. This is the defense of sudden fight. So going on to the fourth defense, a very, very popular one, self-defense. For example, somebody come rushing at me with a knife in his hand, and I fear that my life is in danger. Then in turn, I decided to take a stick, and hit him on the head, killing him in the process. This one is really a classic example of self-defense. But of course, your self-defense, it cannot be disproportionate, meaning to say, for example, the person rushed forward and tried to throw a punch at my face, and I decided to take out a gun and shoot him. It cannot. This is not self-defense because it's disproportionate. These are some of the commonly seen defenses used in murder cases in Singapore. They are not mutually exclusive, so there can be one, two, or three all together at the same time in one murder case. Of course, ultimately, we know that prosecutorial discretion in Singapore is unfettered. They have the ultimate discretion to decide which charge to lay against the accused person. It's the same for murder as well. Ultimately, really a lot depends on whether they have the evidence, on whether they can prove the elements of the murder charge. In the event, for example, like Orchard Tower, for instance, whether is it from an evidential standpoint or from a factual standpoint, they feel that the charge of murder is not made up for one individual, for instance. That is where they have the discretion to either amend the charge to something else in terms of the elements of it, or they can even reduce the murder charge to another offense altogether. For example, like a voluntary causing hurt offense, or maybe reduce it to a consorting offense, for instance. There are really many permutations to this, but ultimately, the Attorney General's Chambers, or in short, we call it the AGC, they have the ultimate discretion. So for the four different types of murder in Singapore, only Section 300A of the Penal Code carries the mandatory death penalty. What it means is that upon conviction, the only sentence that can be given is the death penalty. In Singapore, the death penalty is administered by hanging. As for Section 300B, C, and D, if you are convicted of any of these three, in terms of the sentencing, after conviction, it can either be the death penalty or life imprisonment with caning. The death penalty applies to people when they commit a capital crime of murder at 18 years old. But assuming if at the time of the killing you are below the age of 18 years old, then the death penalty doesn't apply because it's based on the material time as to your age. It applies both ways to both sexes, both men and women. Just to talk a little bit about life imprisonment in prison or street lingo, it's quite funny. It's a bit morbid also lah. They say that, you go in makan but you come out tapao lah. That means to say you enter prison alive but you come out dead. So the default position is that you'll spend the rest of your life in prison until you die lah. It's like whiskey, neat no rocks. So solid 20 years without remission before you can be considered for parole eligibility. And every year there will be an interview to see if you are eligible to be released early. And of course, to talk a little bit about caning in Singapore, the maximum number of strokes allowed would be 24 strokes. By the way, fun fact, caning in Singapore cannot be done in installment, just in case you think, okay, this month cane 2 strokes, next month another 2 strokes. It doesn't work that way. For example, if you are given 24 strokes of the cane, all 24 strokes will be administered in one go. Caning doesn't apply at the time of the caning process to people above the age of 50 years old. For men, there's no caning applicable for women. Caning wouldn't be imposed for people with medical condition. But of course, as to whether the medical condition is serious enough, that will be determined by the doctor in attendance before caning is administered. But there's a provision in our laws that state that if for whatever reasons you cannot be caned, then that caning can be converted to additional jail time in prison. There are really just 2 parts. Either one, a case cannot be made up in any of these 4 types of murder. Or it could be a case whereby the defenses or the exceptions to the murder charge succeeded. And that is where the murder charge itself cannot stand.
I eat can, you eat cannot. Okay, I eat won't die, you eat will die. You can only watch me eat. Very nice.
Obviously not interested.